My Lord,
Yes.
part two of my submissions was the distinctive and significant features of this particular case, and this will be quite a short section.
Yeah.
The first feature is the point I made. MW was a defendant Part 20 claimant in the earlier action, and I've made the point that that is a feature that distinguishes it from the other authorities in the bundle where the party who was being accused of abuse was a conventional claimant in both actions.
But vis-a-vis Outotec, you were claimant.
Correct. But the reason...
So the fact you were defendant vis-a-vis EWH, of course, that I appreciate that's part of the context, and you would say an important part of the context, but surely what matters is that vis-a-vis Outotec, you were claimant.
My Lord, we accept that we were vis-a-vis Outotec claimant, but there are two headline points under this heading. The first is that unlike a claimant who is pursuing a remedy in a conventional setting, and who obviously is expected to bring all such claims for such remedies at once, MW's central objective in the earlier action was defensive. It was seeking to avoid liability rather than to gain. And my second point, and I will develop all of these in the sections that follow, is that in my submission it must be correct that the scope of any Part 20 or downstream claim, as it's sometimes called, that a defendant pursues will be strongly influenced by the scope of the claim it is seeking to defend. And as my Lord said, that is part of the context in which I would want to say that the conduct of MW needs to be considered. It is a facet that doesn't feature in the other authorities, and I will, as my Lord, you rightly say, be saying that it's a significant feature. The second point is that the parties are engaged in a series of claims relating to the three projects. I mentioned in my opening section the overlapping nature of the misrepresentations alleged, and I just wanted to show the court some specific paragraphs of the particulars of claim on that. So could court look to core bundle, tab 7, page 86, which is the particulars of claim in the current case.
Sorry, just hold on. Where are you, please?
Core, tab 7, page 86.
Thank you.
Before I make my submission, my lords, I should just clarify something. These are now out of date. These are the original particulars of claim that were served by MW in relation to this action. What has happened since is that there have been...
Or do we need the up-to-date one?
My lord, I think you do.
Well, why haven't we been provided with it?
Well, my lord, that's a fair
You can't
question.
make submissions halfway through the day of an appeal and say, you've got the wrong documents.
No, my lord, it's a fair question. From my side of the table, I had thought that the reason the original particulars were being relied on is because it was going to be said that the abuse occurs at the point and in the form that the second claim is launched. But my lords, with hindsight, I can see it probably would have been helpful. In fact, it would almost certainly have been helpful.
I think that is Mr. Williamson's case.
Yes.
I mean, he says the claim must be struck out, and therefore you've got to view it as in the form that it took when it was brought.
And that's, my lord, that's why I didn't take the point, as it were, that you need to see the amended particulars. But the way the arguments have developed, including in relation to the question of defects, which I'm going to come to, it seems, my lord, that it may be of assistance to you for a comparative exercise to see the amended particulars. And of course, if we can assist the court with that, we will. But I appreciate Mr. Williamson will have submissions to make on that.
Since I'm asking questions, can I ask another question?
Yes.
You described your client's position in the first proceedings as defensive, and I understand why you say that. But it is your case in these proceedings that, but for Outotec's misrepresentations, it wouldn't have entered into the main contract or the subcontract. So why would that not equally have been a defence?
Well, my lord, it wouldn't have been a defence to the main contractor's claim. The proposition that we would never have entered the main contract would have been a claim against Outotec. But the fact is, we did enter the main contract with the employer, and the employer had valid contractual causes of action to vindicate. So even for us to succeed 100% and say, well, but for your misrepresentations, we would never have been in this contract, is a matter that exists purely between us and the subcontractor.
I appreciate it, of course. Legally speaking, it's not a defence, but why is it not commercially a complete defence? Because you're asking for all of the money back. So
Well,
commercially speaking, it's a complete defence, isn't it?
well, my lord, in a sense, that throws us forward in my submissions to the question of the different scope, the different nature of the inquiries, the different evidence that these different claims involve. My lord, I think I would accept in the abstract your proposition. I don't mean that in a derogatory way, but I think what I will be saying is that when you look at the fact and you look at whether that really could have taken place in a practical sense in this case, I'll be submitting that it couldn't. So, my lord, just to conclude this point about the pleadings, as I say, we can make the amended particulars of claim available if we need to. The point that I'm going to show you now has not changed. So that is of some help. And I want to show, my lords, page 90 of the core bundle, paragraphs 10 to 15. Under the heading, the pre-contract representations, and this is where we introduce the misrepresentation case. And you see at paragraph 11 that the period identified as relevant is the period between February 2011 and November 2015, when the parties entered into this subcontract. The parties engaged generally in communications regarding, parties engaged in communications generally regarding Outotec's plant technology, and also specifically in relation to the Hull project. MW relies on the representation made during that time, which is detailed below and is set out with more particularity in Schedule 1. And paragraph 15 on the next page, in the premises, this is MW's case, representations made in relation to all of these other projects prior to the date of the subcontract and to individuals employed by MW in relation to the Hull project and other projects were necessarily also representations made in respect of the Hull project. And the court, just to understand what the other projects are, if the court goes back up to paragraph 12 on the previous page, you see that in fact there were 7 projects in discussion, 3 of which went into contract and 4 of which did not. So that's Levenseat, Hull and Surrey became contracted projects. Veras, Billingham, Doncaster, NEC did not. So again, just why do I say this is significant? Well, I say, and will develop, that the outturn of these multiple parallel disputes is that Outotec faced the prospect of successive trials in relation to each project. And that's not a feature that is really replicated in any of the authorities. There is, in my submission, an analogy of sorts with the Barrow and Bankside case. That, my lords, was the Lloyd's litigation case. It's at tab 1 of the bundle. I don't particularly propose to go to it. But the point there was that the claimant, or the court, in an early exercise of very significant commercial case management, had divided up the different types of claims that the members had against names, against managing agents and the like. And they said, well, we're going to try these claims in stages. And what happened was the claimant had one type of claim, he brought it, he partially succeeded. He then popped up with a second claim of a different nature, and the defendants said it was abusive. The court found against them on that and allowed the claim to proceed, primarily on the basis that there was always going to be these plural trials as a feature of the Lloyd's litigation. Now, I don't say the analogy is particularly strong, but there is an echo of some of the things I'm going to talk about. And as I say, on the facts in that case, no abuse was found. The third feature, before I move on, that I say is significant is the presence of the claim against Mezzo as a guarantor. I say it's significant for 2 reasons. Firstly, that it helped to frame the judge's assessment of the abuse arguments against, in relation to Outotec, and I say he was right to find, as he did in his judgment, and perhaps I can take you to it. That's core bundle, tab 5, paragraph 102 on page 66. If I could just ask my lords just to reread that paragraph rather than me read it out. Well, as I say, he framed the analysis in the right way, and secondly, the presence of this ongoing claim against Mezzo that was not abusive and will need to be tried anyway, was, I say, a powerful factor undermining the allegations of oppression made by Outotec. From the synopsis I have given, the court will see that the situation on this appeal is that the very facts which the appellant says were actually irrelevant are the facts that I say were singular and important features that carried particular weight in the mix on this dispute. I move on to part 3 of my submissions, which is the legal propositions that I wish to emphasise, and there are 5 of them. My first proposition is that the court should proceed with care when facing an assertion that some particular aspect of the case is irrelevant given the broad merits-based nature of the inquiry. I make good that proposition by reference to Goldberg, which is in tab 3 of the bundle. That's the Stewart and Goldberg Lindy case. Tab 3 of the authorities bundle. My lords, if you could look at page 52 of the continuous pagination, which I note my Lord Stuart-Smith does actually begin on the first page, which is novel.
Goldberg page.
Page 52, or internal page 839.
Yeah, but my paper bundle doesn't have successive.
No.
So,
In that case,
These
there's no novelty.
like judges, are just sent twice. That's all.
So Goldberg paragraph.
57, my lord. The court was here dealing with a suggestion, which doesn't arise here, that the merits of the underlying claim were irrelevant. And actually the court went on to find that they probably were irrelevant, save in extreme cases. But the point I want to emphasise is towards the middle of that, or near letter G. So given Lord Bingham's emphasis on the need for the court to adopt too dogmatic an approach to what should, in my opinion, be a broad merits-based judgment, ... it is necessary to proceed with care in relation to a contention that some aspect of a particular case must be disregarded as irrelevant in principle. And I say that proposition has particular force in relation to Outotec round 4, where their appeal is precisely that 2 of the things the judge took into account in the broad merits-based inquiry were irrelevant.
Well, one has to read on, doesn't one? If you look at the top of the next page, what he says is that when the merits he had in mind were not substantive merits or otherwise of the actual claim, so that is irrelevant.
Yes.
But those relevant to the question whether the claimant could or should have brought his claim as part of the earlier proceedings. So, would you submit something that is irrelevant to that question is nevertheless relevant for some reason? If so, why?
My submission is a compact one, Lord, and if I didn't make it clearly. It is just simply that you should proceed with care and scrutinise the suggestion that a factor in the mix is irrelevant, because it is quite a strong submission to make where the law is clear that this is a broad, non-mechanic, merits-based inquiry where the judge needs to look at the merits of the picture in the round. My submission is just that, as I say, you should treat with caution, and I say this passage does support me on this, the suggestion that something in that picture is irrelevant. I quite accept, my lord, that you're right, it has to go to the question to which it goes is the broad merits-based judgment.
Yeah.
My second proposition is that the Aldi guidelines are only one facet of the Johnson and Gorwood broad merits-based judgment, which determines whether striking out for abuse is a just outcome. I don't propose to take my lords to authority on that because I'm sure it is common ground, but I emphasise it.
Or just for the note?
Well, my lord, you can find it in Threadneedle, tab 5, page 94, at paragraph 49.
Tab 5, page
94,
para.
49.
Thank you.
So, can you help me as to what you mean by that? I mean, I take it that what you're submitting is that non-compliance with the Aldi guidelines is not automatically to be equated with abuse of process, correct?
Correct.
But would you accept that it's a strong pointer towards abuse of process?
I would, and I would qualify that by saying that one does, however, need to look at the circumstances of the non-compliance. I can't pretend, my lord, in the face of 5 Court of Appeal authorities that say the Aldi guidelines are very important, that they are not important. They are. But I'm going to spend some time in my submissions explaining to the court the particular circumstances of the non-compliance in this case.
So that's consideration of, what did you call it, culpability? Did you
Yes.
say? Yeah.
I think
My
the reference we had from Mr. Williamson this morning was paragraph 65 of Gladman, which refers to irrelevant matters pointing to a conclusion. That's, I think.
My lord, is that on my proposition 1?
No, on 2, in my Lord's question,
I see.
are you accepting that it? I think he added in a strong somewhere along the question, but
My lord, I think I have to be realistic and say that the jurisprudence shows that within the broad merits-based inquiry, the Aldi guidelines are very important. But I do say they are one facet of the inquiry, and you need to consider everything else. My third proposition is that there are circumstances in which steering a reasonable course through complex litigation may involve bringing different claims in separate successive proceedings. Now, my lord, that is in some senses a proposition of fact rather than a proposition of law, but it finds support in the judgment in the Aldi case at tab 2 of the authorities. Could my lord please look at page 31 of the bundle, paragraph 18. What Lord Justice Thomas is doing in this passage is explaining, in essence, why on the facts of this case, he felt that Aldi had steered a reasonable commercial course, even though that involved the bringing of successive claims in relation to the same basic factual background. So it is not the case that the presence of successive trials arising out of the same facts, or as it was put by my learned friend, the same project, is automatically or even strongly an indicator of abuse without more. It all depends on why it has happened in that way. I've given the illustration before of a bankside case as another type of illustration where this happened. My lords, proposition 4 is that when assessing the seriousness of a breach of the Aldi guidelines, it is relevant and important to consider the counterfactual of how the allegedly abusive claim might have been tried. I draw support for that proposition principally from the Threadneedle case. I'd like to show you a number of paragraphs from it. It's at tab 5 of your authorities bundle. Beginning page 89, paragraph 8. just to very quickly sketch the facts, my lords, this was a case where the first claim involved a claim against employees for various breaches of covenant and the like, and the second claim was sought to be brought against the employer, alleging vicarious liability. In paragraph 8, Lady Justice Arden, as she then was, summarizes her findings, and in so doing, she refers to what she had defined as the hypothetical scenario. You see the hypothetical scenario is defined in paragraph 7. In this case, the Aldi guidelines had not been followed, but the judge found that it was likely that if they had been followed, the court would not have required Threadneedle to be joined as a party to action 1, and he calls that the hypothetical scenario. The judge took the view that in all the circumstances it was not appropriate to strike out action 2. One of the points Threadneedle makes is the judge should not have inquired into the hypothetical scenario and came to the wrong conclusion in any event. And she then goes on to dismiss the appeal, uphold the judge that there was no abuse in paragraph 8. Towards the end of that paragraph, she says in the final 2 sentences, in considering the seriousness of non-compliance, the judge had to consider the hypothetical scenario. The judge weighed the circumstances correctly and was right to decline to strike out action 2. He was also entitled to make his costs order because it reflected his view of Outotec's conduct. That's Freudian slip. Ocrates' conduct in particular, not complying. That headline conclusion is taken up in a number of other passages, which I'd like to just briefly. Firstly, paragraph 14 on the next page. So that's page 90, the bundle. Sorry, it's not, it's page.
Don't worry about the bundle numbers, because none of us have an paginated bundle.
I'm sorry about that.
That's right, just the paragraph.
Paragraph 14, this is where she's dealing with what the judge found.
Yeah.
The judge took the view that where a party had not complied with Aldi and the court was asked whether this was an abuse, the court ought to go on to consider as best it could what would have happened if management direction was sought. He considered that there should be a high threshold for concluding that non-compliance with the Aldi guidelines was an abuse. Paragraph 17, still with what the judge found. The judge found that even if Ocrates had complied with the Aldi guidelines, the commercial court would have declined to make an order to join Threadneedle because that would delay the trial. There were legitimate reasons not to delay the trial and reasons why it might be delayed. For example, Threadneedle bringing a substantial legal team and might wish to bring proceedings, etc. She then recites the submissions that were made by leading counsel on the appeal on this, which were at different points on the spectrum, different ends of the spectrum, in fact. So in paragraph 24, over the page, in fact, it's printed as 23 twice, but it should be 24, beginning Mr. Malik submits that the court should strike out.
Yeah.
Mr. Malik submits that the court should strike out action 2 if it is possible that the court in action 1, if asked for management directions, would have directed the claimant to join a particular party which it seeks to sue in action 2. So that was the way it was put by the one party. And then at the other end of the spectrum, counsel, if you turn over, my lords, to paragraph 33, leading counsel for the claimant submitted there has to be a causative effect between the failure to comply with the Aldi guidelines and any prejudice. Mr. Pillar accepts that the failure to comply with the Aldi guidelines is a factor which can go into the mix because the court is required to produce a broad merits-based judgment. He also accepts that if the court is unable to be sure as to some matter of fact, it may be able to make an assumption which is favourable to the party that did not have the opportunity of being joined pursuant to the guidelines. So those were the submissions of counsel. And then in discussion, under which begins at the bottom of that page, at paragraph 52, the judge gives her view, which is obviously the one that counts. And the way she expresses it is as follows. In making a broad merits-based judgment, the judge was clearly entitled to assess the seriousness of the breach and so to seek to determine what would have happened if the necessary application had been made. So I reject Mr. Malik's submission, which was an important part of his submissions, that he, that's the judge, should not have attempted to determine the hypothetical scenario. Nor do I accept that any error has been demonstrated in the assessment of what the judge of commercial court would be likely to have done, and so on. So from those passages, my Lord, I'd say that Threadneedle is a very useful authority because it was focusing quite closely on an important aspect of the arguments before your lordships, which is when one is considering the effects of a non-compliance with ALDI, to what extent does one delve into the hypotheticals? My Lord, the fifth and final of my propositions of law to emphasise is about the burden on Outotec. And my proposition is very straightforward, but I want to develop it by reference to some authorities that haven't had much prominence thus far. Proposition is that the burden rests on the defendant to establish that it is an abusive process for him to be subject to the second action. That is trite.
No.
But I will describe that burden in this way, that the burden is for the defendant to clearly show that the second action is an abuse of the procedures of the court, whose effect is oppressive, and which leads to manifest unfairness to the defendant if the second action goes ahead. I want
Could
to
you just give that again? Must show A. The second one was consequences. Must show A. You said the burden rests on the defendant shows an abuse.
Clearly show it's an abuse.
clearly shown an abuse, the effect of which is oppressive, and that, let me qualify it, one way of testing this is whether there is manifest unfairness if the second action proceeds. And just two authorities on this, my lords. The first is Johnson itself. We don't have it in the bundle, but we have the passage cited. And the passage from Johnson that's normally cited, or typically cited, is the passage from Lord Bingham's judgment. But I want to show you Lord Millett's judgment, which has a slightly different emphasis in this passage. You'll find it in the Goldberg case, tab 3. Page 831 of the internal report.
831.
Yes, para 23.
Thank you.
And what this passage of Lord Millett's from Johnson does is set the broader context in which these abuse arguments take their place and gives emphasis to some of the themes that I wish to emphasise to my lords. It is one thing to refuse to allow a party to relitigate a question which has already been decided. It's quite another to deny him the opportunity of litigating for the first time a question which has not previously been adjudicated upon. The latter, though not the former, is a prima facie denial of a citizen's right to access to the court. While, therefore, the doctrine of res judicata in all its branches may properly be regarded as a rule of substantive law, applicable in all save exceptional circumstances, the doctrine now under consideration can be no more than a procedural rule based on the need to protect the process of the court from abuse and the defendant from oppression. He continues, in Brisbane City Council and Attorney General for Queensland, Lord Wilberforce, giving the advice of the Judicial Committee of the Privy Council, explained that the true basis of the rule in Henderson is abuse of process, and observed, that's Lord Wilberforce, that it, quote, ought only to be applied when the facts are such as to amount to an abuse, otherwise there is a danger of a party being shut out from bringing forward a genuine subject of litigation, end quote. There is therefore only one question to be considered in the present case, whether it was oppressive or otherwise an abuse of the process of the court for Mr. Johnson to bring his own proceedings against the firm when he could have brought them as part of the same, as part of or at the same time as the company's action.
Would you accept that that formulation seems to suggest that oppression is not a requirement?
I would. I accept that. It is clearly central to the inquiry in my submission, but I don't go as high as to say it is a necessary precondition. My lords, that passage is more succinctly summarised in the last case I want to take you to, which is the Playboy case, tab 6.
Did the other judges agree with Lord Millett?
I can't answer that immediately.
Okay.
I think the position is stated accurately by Lord Justice Lloyd in the Stuart and Goldberg-Lynn case. End of paragraph 23, the top of the next page. The other members of the House agree with Lord Bingham.
Thank you.
So Lord Millett was in fact in the minority. If there's a difference, although I'm not sure there is.
Yes. Thank you for that, Lord. The final authority then is tab 6, which is the Playboy and banker Natsin Arnold case, and this is a rather more recent judgment of this court. And I just wanted to show you the way the points are condensed at paragraph 54 of that judgment. Because I say this is a passage that captures the defendant's burden very neatly. The burden is on BNL as defendant to identify reasons why bringing the second claim is manifestly unfair. Michael Wilson, partners. The courts will not likely shut out.
Sorry, where are you reading from?
Sorry, my lord. 54. Paragraph
54.
Yes.
Sorry.
I'm so sorry.
Yeah, got that.
The burden is on BNL as defendant to identify reasons why bringing the second claim is manifestly unfair. Michael Wilson and partners and Sinclair. The courts will not likely shut out a party from pursuing a genuine claim unless abuse of process can clearly be made out. Stuart and Goldberg-Lindy. Quoting that judgment, it will be a rare case where litigation of an issue which has not previously been decided between the same parties or their privies will amount to an abuse of process. Well, Lords, I then move to part 4 of my submissions, which is the inquiry focusing on the claimant's conduct. I just want to say this, although I'm dealing with my submissions on the facts under these 3 headings that I've identified, so that's culpability and conduct, it's the ALDI guidelines, case management, it's the effect. I of course recognise that these are not rigid divides. The points under one heading will obviously influence the points under another. It is a broad assessment, but I offer it in this structure as in my submission it helps. Now, Outotec centrally characterises this as a culpability case, and they use that term that say MW kept this claim up its sleeve, and I urge you to reject that characterisation. I will say this is a case where MW neither could realistically and practically have brought its misrepresentation claim within the EWHL claim, or alternatively, it's not a case.
But sorry, the judge has found against you, and there's no respondent's notice.
Well, I'll accept that. Let me rephrase it then.
You
and
also
I'll...
found that you didn't comply with the ALDI guidelines, and there's
Yes.
no respondent's notice on that either.
No, and I'm not going to challenge that finding, but I am going to make submissions about its seriousness and its effect in the broader picture. There is in my submission a live issue as to what the judge found as to whether MW should have brought the misrepresentation case in the earlier action. Because, well, Lord, you were taken to, I think it's paragraph 130 of the judgment. Let me take my lords to it and get it myself.
Could, should, and probably would have been tried.
Yes, so that's paragraph 130.
Yeah.
Now, Lord, I do accept that those words, they're obviously there in that paragraph, but that paragraph needs to be read in the context of the whole section of the judgment in which it appears, under the heading which begins, I think, earlier in the judgment at paragraph 119. And as has already been explored in the exchange with my learned friend, there is in my submission a question mark as to how far the judge was going when making that finding, because he was at the same time simultaneously considering this question as to what might have happened as a matter of case management.
That's the next question.
Yes.
That's the would.
Yes.
Would it have been dealt with?
And he deals, in this particular passage, he deals with them compendiously.
Yes. But having, I mean, if we look at 119 to 130, the judge, a lot of that is actually concerned with the would question.
Yes.
But as far as the should question, is concerned, I mean, he rejects at 122 and 125 the principal submissions being made to him on the should issue. So I'm about to say I read this as the judge finding that it should have been brought. But surely, in any event, if a commercial decision was made not to bring it, the corollary must be that it could and should have been if it had been decided it was going to be brought.
Well, my lord, I'm going to come on to deal with the commercial decision point.
Well, I understand that, but isn't that right as a matter of logic? If you know you've got a claim, but you would say, for entirely reasonable reasons, the decision not to bring it, it's a bit difficult to argue, well, it could and should not have been brought.
My lord, I think I'd accept that in relation to whether it could have been brought, because obviously if there is some form of decision made, then it implies that there were options available. I don't know if I would accept it in relation to it shutting down the should it have been brought inquiry.
But coming back to the point you started with, and my lord's first question, would you accept this much, that the judge has confused two different questions here? Or maybe confused is unfair to the judge, but he's rolled up in one sentence two questions.
I would accept that.
The first is the could and should have brought the claim, and secondly, the case management question.
Yes, I would accept that those two things are perhaps unhelpfully juxtaposed in this sentence. Yeah. And in a sense, my lord, that does go to the submission that I am making as to what my lords take as the effect of this part of the judgment. And I hear my lord loud and clear as to how he has read it. My submission is that it is always important not to adhere to, in too much isolation, to a single sentence of a single paragraph in the entirety of the judge's reasoning. And that when one looks at his judgment more holistically, I have absolutely, I have no disagreement with my lord that he's very clear that he says this is a claim that could have been brought, and I'm not going to pursue that point further, my lord, you're right. But I say it's not as clear-cut in relation to what he has found about whether this is a claim that, looking at all the circumstances, should have been brought. And the fact that he's expressed himself in that way in that paragraph is unfortunate, and it's difficult for me, I accept that. But as my Lord Justice Arnold has said, the context in which that rather unhelpful for me remark appears is focusing on the inquiries to the case management, the possible implications of how this all might have been resolved. So I invite the court to at least reconsider that part of the judgment in light of my submissions as to how far the judge was really going with this.
Well, can I explore that point a little further? Because if you're inviting us to reconsider, then it becomes a bit difficult for you to say that this is an evaluative decision with which we shouldn't interfere. Now, you can, of course, make the submission that he reached the right conclusion, but seems to be a degree of acceptance that we need to re-evaluate ourselves and reach the same conclusion.
Well, my Lord, there is a degree of acceptance to that, and I say that because that flows from the structure of the appeal and the fifth ground of appeal for which the judge was given. And the fifth ground of appeal is pretty broad. It is that the judge, in the overall assessment of the merits, got it wrong. Now, my Lords have already referenced there's something of a tension in the authorities about the mode of this appeal, where one is reconsidering a question of that type. But the ground of appeal for which permission was given is, in contrast to the fourth ground, very specific, is broad. And I have taken it as a necessary part of dealing with that ground to look again quite broadly at the decision that the judge made to try to persuade you that in fact he got it right. Which was my overarching submission at the outset as to what I say about ground 5. Now, as you say, my Lord, it is entirely normal for this court to reach the same version, the same view, but with a slightly different pathway, and that maybe this is one of those cases. My Lord, does that address your question?
Indeed it does, thank you.
My Lords, when dealing with the question of culpability now, I would like to just review some aspects of the earlier proceedings from 3 vantage points. I want to show you very quickly, what the judge said about the evidence that was given to him by MW. Then look at certain points of the judgment in the actions below, because I will be making the submission that the earlier proceedings were legally and thematically and evidentially very distinct from the claim that is now pursued. And I will say a couple of things about the implications for the defence of that action by MW if the hypothetical fraud claim had been brought into that picture. My Lords, can you look at Core Bundle, tab 5, page 68, so we're still in the judgment. And this is the beginning of the section. Could MW have brought the misrepresentation claim in the previous proceedings? And the judge deals with the evidence that was given to him by Mr. Wieleczko below in paragraphs 108 and 109. And it is fair to say he was not persuaded by the points that were there made. However, he notes that one of the parts of the evidence given was that the investigations into the problems at Leave and Seat were ongoing at the time when MW was also dealing with termination of its employment at Hull in March 2019. And the point I want to draw out and emphasise is in paragraph 109 of the judge's judgment, where he refers to the evidence midway through that paragraph. He, that's Mr. Wieleczko, said that faced with a claim from EWHL of a sum in excess of 131 million, M&W's focus at that time was understandably defending its position against EWHL. Now, I submitted earlier that we say it's a feature of significance in relation to culpability that the principal objective of the earlier proceedings was to defend them. And I wanted to show you that resonated in the evidence.
We can't pick bits out in isolation. We're not the finders of fact. The judge did that exercise. The judge made various comments about the evidence, making the point that I confirmed this morning that Mr. Wieleczko wasn't involved.
Yes.
So my understanding is there was no evidence from anybody who was involved.
You were right about that, my lord. They were not the solicitors involved at the Pepperell
So
trial.
I mean I quite understand that happens. So, but we're in a position whereby there isn't, other than the acceptance in both skeleton arguments that a commercial decision was made, we don't seem to have any contemporaneous evidence at all. So where's this taking us? I'm not quite sure. It's my fault, I'm sure. I don't quite understand where this is going.
No, my lord, it's my fault because
I'm sure
I should be signposting it. I think to make things clear, you are right as regards witness evidence. There's obviously was no, and certainly isn't before this court, witness evidence from the solicitors who were leading the EWHL claim from the M&W perspective. But where I am trying to go with this is I am trying to fortify my submission that the non-compliance with the LD guidelines, which I accept and I will come back to and accept again, it has to be looked at in my submission in the context of MW trying to defend itself against a £131 million termination.
Yeah, well, I see the force of that. Yeah. But how does this evidence help you when the judge's conclusion at 118 is that MW could, if it had decided it wanted to, have investigated and pleaded the misrepresentation in reasonable detail by late 2019?
It helps me, I say, because whilst that again is something it could have done, the assessment of culpability needs to look at the question of whether it should have done and what that would have meant through the context that I've referred to and won't repeat.
Well, there's two separate questions in there. One is should have done because the LD guidelines say so.
Yes.
And second, which I think is what you're trying to chip away at, is whether should have done because it was either morally or in accordance with the overriding objective desirable, irrespective of the specific terms of the Aldi guidelines.
Yes, I
Am
think
I right about that?
you're right, my lord. I think my use of the word should have done is probably unfortunate in this context because it might conflate things.
Well, should is quite a loaded word in this
Yes.
context.
Yes. Should have done because the Aldi guidelines say so is very difficult for me to...
Can I raise something which has only just
Hang
occurred?
on, wait a minute. Let him answer the question.
Oh, I thought I had
Goodness
done.
sake.
Oh, I've given him masses of time.
So you accept that there is a sort of separate, potentially a separate distinction. Should have done because of the Aldi guidelines, and you accept that you're in difficulties on that.
Yes.
And then the second question, or should have done from, as it were, a wider sort of moral standpoint.
Let me abandon the word should have done in that second part because I don't think they're helping us. Let me tie it back to what the judge said in his judgment. The judge said in his judgment when he centrally concluded on these issues that this was a case where the breach of the Aldi guidelines was not of the most egregious type. That is really what I'm driving towards because I'm saying he was right about that. And one of the reasons that I say that's a submission that has some force in this case is because the breach, the non-compliance, needs to be assessed and looked at in the context of the difficulties that a defendant in MW's position was facing.
And I'm right in remembering, aren't I, that this litigation we've been
The
talking
present
about,
litigation.
the original proceedings
Yes.
was by no means the only litigation that MW was involved in.
It was,
Didn't I do a trial in mid-2020 involving MW and a different sort of subcontractor?
I'll turn my back, but that rings a
Well,
bell.
I'm pretty sure I did.
You would probably remember. So.
And I think
But
But
we
that
don't
might
have
not-
any evidence. I mean, there's
that
no...
might not be this project, because I'm sure I've done at least one judgment in a case that starts MW.
No, but
Yes.
it was in, my case was in Hull,
Oh,
Yes,
right.
I'm
and
told.
it was to do with weight. And someone thinks I did. Someone on the back row.
Yes.
But my only reason for raising it is, although I understand why you're trying to sort of flesh out the context, we are limited really to A, the judge's findings, and B, the witness evidence, which, as my lord has pointed out, was not first-hand anyway, although no one would have objected if he'd said we were engaged in these 14 other cases. So, I'm a bit like my lord, I'm a little bit troubled. I can understand why you're saying you're bolstering not of the most egregious type,
Yes.
and I think you're entitled to do that, I would say.
Yeah, I agree.
But
Well,
however you reformulate it, once you go much beyond there, I think
So anyway, the point that you got to is, so you
he's
say,
listening.
because of the conduct, or because of the position in which they found themselves, the context of the difficulties that they had in the main action, being the defendant and so on, you say that supports the judge's view that this is not the most egregious breach of the Aldi guideline.
It does. And the other aspect of this that I was going to develop, but perhaps I'll try and just put it succinctly, is I was going to spend a portion of my time in submissions underlining and underscoring the really significant disconnect in terms of the evidence and the issues between the earlier action, that's the Hull action, and the present action. Now, I understand that to a large extent it's common ground. Certainly it's common ground that the misrepresentation case is about those those events from 2011 to 2015. What I was going to show, my lords, but perhaps I don't need to, but I'll make the submission.
I mean, the judge, did the judge not say that?
Yes.
I mean, the judge, on overlap, the judge said there was very little.
Yes. Yes. So perhaps I'm pushing an open door, my lords. Let me just put the point this and I'll move on. The issues, as was shown in outline by my learned friend in the Hull proceedings, were all driven by the fact that it was a termination dispute. And it all centred on events in the commissioning period of around 2017, 2018. That's what that claim's fundamentally about. And as you saw in his submissions, the structure was a very familiar one. The employer terminates because a delay liquidated damages cap has been reached. The contractor says, in fact, it was entitled to an extension of time. There was an enormous amount of analysis by Mr. Justice Pepperell of the critical path of those delays, but it was all about the period towards the end of the works before termination, commissioning.
Well, forgive me if I've misunderstood. I thought there were three aspects to the claim. There was, as you say, termination, delay. There was also a claim about defects, was there not?
There were claims about defects, and we may need to get into those. But my submission is those were not, in any sense, the dominant or driving issues. In a sense, one sees it.
It's a goodly chunk of the judgment.
Well, that I can't disagree with, and I don't in any sense mean to underestimate the judge's work in dealing with them. But, my lords, I think I'm going to move on because I think, my lords, that's what I should do.
Can I just ask you one thing about this question of overlap? Because,
yes.
You know, the judge clearly thought that there was largely no overlap.
Yes.
But in one sense, the damages claim in the new proceedings overlaps the old action completely.
Yes, I see, my lord.
So when let's assume the new claims fight out, there'd then be causation issues in relation to each of the heads. Wouldn't that then involve revisiting the findings in the main action?
Well, my lord, it will be pursued. It is being pursued, I'm sure, as effectively a reasonable settlement case. It's big and impermanent.
Well, the 75 million,
yes,
big and impermanent,
yes.
I understand that. But then that big and impermanent in a complex case does involve reconsideration. So it's a really odd position. I can see, and for the most part, I think it's right to say that there is very little overlap on the primary allegations. But you would, when you get to causation and damage, you could be straight back into it all.
Well, my lord, I think in litigation as complex and as multifaceted as this, it would be brave for me to submit that there's never going to be any overlap or any issues where there need to be some revisiting. But I don't concede that the evaluation of the causation of those losses is going to need a rerunning of the whole proceedings. And my lord, while we're on this topic, I wonder if I could just say something further about defects, because I don't want to push an open door. There are things that perhaps the court should be would help to clarify things arising from the exchanges with my learned friend before lunch about issue estoppel, because what Mr. Temminck, had he been here, would have known immediately, and what I've only been reminded of, is that part of the application before the judge below was an issue estoppel argument. And I'm going to hand up and I've given my learned friend a copy, just the application notice, if my lords will take a look at it. Because I suspect this point is going to be common ground, so I don't want to labour it. But what Outotec applied for to the judge was three things. They applied for abuse of process, which is what you and I are dealing with. They applied for a declaration, which they succeeded in obtaining, that the reassignment of the contract was ineffective. And they applied at item 3 to strike out certain alleged defects claimed by MW at paragraph 73, 74.1, 74.3, 74.4, the list goes on, as an abusive process on the basis that the claims are being brought which have already been decided in the original proceedings. Now, what I am told is that in the course of the hearing below, this was the subject of oral argument, and if my lords want, I can take you to Mr. Temminck KC's skeleton for the argument below where he dealt with this. But essentially, I am told that Outotec decided not to pursue these allegations, and that's why the judge doesn't deal with them in his judgment.
Was
But
the suggestion that the issue estoppel arose because in the original proceedings it had been found that these defects were not the responsibility of Outotec? Was that the case?
I don't know, is the honest answer.
Well, Mr. Williamson was there.
Mr. Williamson was there, so he can no doubt assist. And I don't. If I'm misspeaking about this, then I apologise, because obviously I wasn't there. But the basic point is, this issue estoppel argument was taken, but then I am instructed abandoned. The judge therefore doesn't deal with it as a head of the application in his judgment, but what the judge was left with, helpfully in the context of the broad merits-based inquiry, is that he had heard argument about the extent to which there was overlap or not overlap between the findings of the judge and the pleading claim. And just to put one further point on this, the central reason that MW says there's no issue estoppel here, no res judicata type point, is because it is not seeking to contradict Mr. Justice Pepperell's finding. Quite the contrary. It seeks to make a virtue of the fact that where he found defects, they adopt them. And I will, for that, just show you my learned friend.
Where he found defects as against MW.
No, as against Outotec. In the Part 20 claim that was...
Oh, I see, where he found defects against Outotec.
Yes, and let me show you my learned...
Where he found defects against Outotec, then that's been assessed by way of damages in the main action.
Yes, can I just take...
We don't have to worry about that again, surely.
Take my lord to the... can I show you supplementary bundle tab 7, page 331 of the paper, or 333 of the PDF.
Starting paragraph 3.
In fact, I've given you the wrong page. It's 329 or 331 of the PDF. So, paragraphs 48 onwards. This is, no, sorry, my lord. This is Mr. Tennant, King's Counsel's skeleton argument. And you see on page 329 under heading E, application 3 certain defects. This is where he made MW's submissions in response to that application, or that part of the application. The first issue was about mezzo, which doesn't directly concern us. The next from paragraph 48 onwards were the submissions that I want to show you. You see that he was taking the point that it was inappropriate for the judge to deal with these as matters of summary judgment, or strikeout. That's paragraphs 48 to 49. I wanted to draw your attention particularly to paragraphs 53 to 54, and perhaps just ask my lords to read those. Now, my lords, in the end, this is all something of a digression from my submissions, but I thought it might be helpful.
Great assistance, but I'm still a bit in the dark, because surely the question is, were there defects or were there not defects? And Mr. Justice Pepperell made findings on that, didn't he?
Yes, he made an array of findings as to some defects being proved, some not being proved, some being proved but not notified, some being notified but not claimable for other reasons. So, yes.
Right. Now...
But MW's position, my lord, is that we are not, far from trying to go behind those findings, we are seeking to use them. That's our core position.
In which case you would have pleaded issue estoppel yourselves.
Well, yes,
apparently you haven't.
I see that. No, I don't recall that that it is pleaded in that way. Can I just turn my back? Yes, I think the point I'm reminded is that the
And do you accept the adverse findings where he found that there were no defects?
yes, my understanding is that we have not sought to resurrect or try to rely on defects where Mr. Justice Pepperell said there wasn't a defect. My Lord, can I just suggest this in the interests of time, that if my Lords would like a more detailed note or account of the interrelationship between the defects findings and the main judgment.
That's appreciated.
We could do it overnight.
As an offer, but maybe we can cut this short, because you made it clear that you're not trying to resurrect where there was no finding of a defect.
No.
Where you are relying upon findings that there was a defect, as I understand it, you accept you haven't pleaded issue estoppel, and I think you must accept that inevitably follows that as matters stand, the questions have to be retried.
Well, only if they're disputed. And the question is, we're also not relying on those defects as claims for damages in themselves. We are only pointing to them. Effectively, they become part of the evidential landscape. We are pointing to those defects when they arose in contractual performance as ex post facto evidence that the misrepresentations when made earlier were likely to have been false. And the judge in this action will have to assess the strength of that. But that is the purpose for which the defects are now pleaded. They're not, sorry.
But can I just, while the thought's in my mind, try and clarify what you just said? I think it follows from what you just said that Outotec are on the horns of a dilemma, because you say, although you haven't pleaded it, you rely upon the judge's findings in the previous trial. And so you are putting them to the dilemma of either accepting findings made at a trial at which they were not present, or relitigating them.
No, my Lord, I don't accept that.
Wait, sorry. So not present, of course, is wrong. They were present, but they weren't. Were they party to those disputes?
Yes,
they were.
Yeah, they were. And my Lord, you have my sympathies, because we are all trying to deal ad hoc with what was really quite a complicated aspect of the picture. But my Lord, we haven't pleaded it as these are findings that Mr. Justice Pepperell made. You're stuck with them. There's an estoppel, and it hasn't been defended on that basis either. We have repleaded as fresh propositions of fact that there were defects with various aspects of Outotec's works, and that those support our fraudulent misrepresentation case.
All right, but can I rephrase what I was saying previously? What this amounts to, as far as defects is concerned, they are being required to litigate the defects twice, but now in a different context.
They're certainly litigating twice, and the context is different, but I don't accept that they are required to relitigate the existence of these defects. My Lord, I'd have to go and see what they've said in their, remind myself what they've said in their defence about any of these points. We may be arguing about something that is in fact common ground.
As I understand what you're saying, sorry, turn it back.
Yeah, sorry, my Lord.
As I understand what you're saying, you accept that the presence of some defects may be common to the original proceeding, Part 20 proceedings, and here. You've explained that you rely upon them differently here as evidence of the falsity of the representations.
Yes.
And you say that, I think this is what you're saying, if there was a dispute about the defects, or in the light of today's conversations, in any event, you may need to amend the plea is returned by
My Lord, that's a helpful summary, and I would only add that the fact that Outotec has not itself taken some point that we are seeking in any way to improperly reduce Mr. Justice Pepperell's judgment.
Well, the one thing you're not doing, as I understand it, is taking a Pepperell decision and saying that's wrong. We want to relitigate it.
Quite.
Okay. Well,
yeah, and you took us to paragraphs 53 to 55. Isn't that showing that you are relying on the defects not just in terms of the misrepresentation, but you making a claim for those defects because you say the judge was limited to the costs of rectification under clause 37. Now, claiming what you said was all the damage due as a result of that defect. That seems to be what Mr. Temmick's skeleton is setting out.
And I think that, yes, well, I think that's right, but I think that the reason that so it may be that when I said that the sole presence of these defects is their evidential value, that's not right. But the reason this is not in any sense a sort of duplicative or repetitive claim is because we did not, one has to track back through the history of the contractual cause of action. So we originally pleaded what I'll call a full spectrum breach of contract claim against Outotec in the Pepperell proceedings. But following the preliminary issues judgment of Mrs. Justice O'Farrell, the contract claim was, to all intents and purposes, removed because of the assignment problem. What then happened on the unusual facts of this case is that as part of the settlement with the employer, there was a purported reassignment.
Yeah.
So when these claims were first pleaded, and remember, my lord, at the point this skeleton argument was written, we believed, incorrectly as it now turns out, that we had a valid contract claim afresh because we had taken a reassignment.
Well, I get...
We now know that we don't have that claim because Judge Davis struck it out.
So you referred earlier to an amended particulars of claim.
Yes.
Is that an amended particulars claim which amends the claim to take on board all that Judge Stephen Davies said?
Yes, and I have the advantage that I did actually help to draft that one.
Right. Well, I think that, not for now, but I think we do need that.
You do, my lord. And with hindsight, I can see that, frankly, it was clear you needed it. And I accept
there it is.
responsibility for
But
it not being.
we do need that. So that's an amended particulars.
It's an amended particulars of claim.
And is it, and of course this question didn't need to be asked, but now it does it show the amendments in red?
It does.
Excellent.
And some of them.
I know it sounds very old-fashioned, but these days you get amended pleadings, you can't work out what the amendments are.
No, the colours are certainly used, and we will of course make.
Pink.
Yes, some of them may not be red, but they'll be the appropriate colour.
Fine. Okay. All right. Well, if we could, I don't think we don't need to pause now, and we do carry on. But if you can make a note, or if Mr. Velichko could make a note that we need the amended particulars of claim. Thank you very much. Yeah.
My lord, the last thing I wanted to say, coming back to the structure of my submissions, and it's probably the last point of ability.
Yeah.
Where again I am asking you to look at it is the question of the impact of the misrepresentation claim on the defence of the earlier proceedings.
You mean MW's defence?
On MW's defence. And Mr. Temmick uses the colourful phrase in our skeleton argument, jurisdiction suicide. What I will say is this.
Colourful or not, the judge wasn't buying that.
No, I agree.
The judge made the point that it is very common in the TCC for main contractors to have to look both ways.
But, my lord, it absolutely is, but this is not a common variant of that problem. It's one thing in my submission to look both ways in the sense that one denies a breach of a strict obligation, but in the alternative says if we're wrong about that, it's your fault. A similar situation is one might say to the employer, no, you're misinterpreting that contractual provision, but if we're wrong about that, then we have our claim guaranteed. But the fraud claim, the representation claim we now bring is that Outotec lied when it said that its equipment and technology worked. And in my submission, notwithstanding my recognition of the main contractual dilemma as it usually features, it's difficult to see how that case could simultaneously be run while defending the termination and delay and defects claims.
That goes back to the very first question I asked about Mr. Williamson this morning, about the difference of brought, which is the word the judge used, and the word raised, which is the word in the authorities. Because what you're talking about is effectively the difficulties of putting forward a full-blown circumstances where I get that. But if we're talking about raising it with the court, don't different considerations apply?
My Lord, I accept the distinction between raising a claim for the purposes of discussion and pleading it. Of course I do. But, my Lord, in this particular case, this is an unusual case in a number of ways. What does the Aldi letter say? When one raises a claim, one has obviously got to say enough about it that there can be an intelligent discussion of it. And it would have had to say that MW, and this would of course gone to the employer, MW wanted to raise a case that the entire process train was not only the subject of widespread problems in operation, but that it had been sold falsely, and that Outotec had known that all these problems existed, and they had lied. And this would have been in the full view of the employer. Now, I am in a difficult position, my lords, because the Aldi guidelines have been described by Lady Justice Arden in Threadneedle as having no exceptions and all that sort of thing. And my Lord Justice Arnold said that there is a reference in one of the other cases to it's not an excuse not to comply with Aldi because the other issues are complex. I accept all that law, but there have to be in my submission, there are circumstances where it comes under real strain and real tension as to how a party in MW's position is to tread that line. And as I said earlier, and I won't labour the point, it is a novel feature of this case, and it is a difficulty. And all of my submissions on this point have ultimately gone to, in the end, although I appear to differ from him, perhaps unintentionally, I'm trying to support the judge's finding, where he said this was not a case of the most egregious breach, and he weighed that against the other factors that he found to tip the balance back in our favour. And I submit he was right to do so.
Speaking entirely for myself, I think we're right at the heart of the appeal here.
Yes.
Because everybody agrees, so you have to accept you're in breach of the Aldi guidelines and so on and so forth. But I have two related questions to which, at the moment, I do not know the answer. And I'd be grateful for your assistance. And Mr. Williams, firstly, what do we do if we consider that it would not have been reasonable to require MW to bring the misrepresentation claim while defending the main proceedings? And second question, which is closely related but I think different. What do we do if we conclude that a possible proper response, assuming this has been raised, was to hive off the misrep claim? Because neither of those views that I've outlined sit very comfortably with what Judge Davies, very experienced judge, formed a view. But we do have our own experience, and we must be in a position to form a view as to whether it's where it is on the spectrum, or more or less where it is on the spectrum, between litigation suicide and perfectly acceptable to require you to run the misrepresentation argument at the same time as the sort of more standard Part 20. And at the moment I don't know the answer to that question, but if you, and it may be that you want to come to it later, but for me, at the moment, those are the two questions that are likely to determine the outcome, my attitude to the outcome of this appeal.
Well, my Lord, I think I can give you the answer, because this really goes, my Lord, I agree we're at the heart of the appeal. We're also at the heart of my submissions, because what I say is that it is the presence of those very distinctive features about the difficulties of having to run this claim alongside the defence, and the fact that there were these available case management options that ultimately undermines the abuse case. Because the central premise of, now let me rephrase that, a key ingredient in the abuse inquiry is whether there is oppression or harassment. And in answer to my Lord's question, if you take those views, the necessary corollary of so finding is that there would always have been two sets of trial proceedings. And what that would lead you to, unanswerably in my submission, is the conclusion for which I have argued, which is that Outotec's abuse problem, that they would always have been vexed twice anyway.
Why? What do you say to the proposition that misrepresentation could have been tried first?
Well, my lord, then we are into the difficult speculation of whether how the misrepresentation claim might have ended and whether they would have been vexed once or twice, depending on how it all turns out. But I would say that there is, and this gets me into my submissions on case management, because I'm going to say, my lord, to answer you directly, that the idea that the misrepresentation claim would have been tried first is not a realistic one. And I say that with all due deference, but I say that principally because, again, we have to remember the employer. That is the distinction between this fact pattern and so many others, that it wasn't just a case as to how bilaterally between MW and Outotec should these issues be arranged. The employer was the claimant. The employer had terminated. The employer wanted 9 figures of damages. And I will submit that the idea that the employer would ever have consented or really that the judge would have allowed the resolution of those rights to stand to the side while a downstream dispute between MW and its subcontractor played out is in my submission, improbable. And again, it gets me back to these central distinguishing features of these facts. But perhaps what I could...
So we're coming to now headline 5.
Yes.
The ALDI guidelines with the case management element.
Yes, and as I said, my lord, so the points blur into one another. I accept that compliance or non-compliance...
They do blur into one another, but I'm slow-witted, so I need the headings, you see. Otherwise it all goes wrong.
No, you're quite right.
So that's why it's very helpful to have your batting order at the start, and I've just read to you what I noted as your fifth item in your
we are at number 5. We're getting towards the big hitters in the batsman order. And at 5 and 6, they are some of my most destructive players, because we now move on to the case management aspects of it. I hope, frankly, and I hope realistically, that we are in touch. I've wanted to say about culpability. The other
your acceptance of your breach is very realistic, but when it comes to culpability, would you accept at least the question is why there was non-compliance with the ALDI guidelines? So I take your point that you say your clients were in a difficult position for all the reasons you've explained. I understand all that. But the ALDI guidelines focus upon notification.
I agree.
So you notify your prospective defendant and you notify the court. So what's the excuse for not notifying?
My lord, I have done my best to answer that question. Effectively, what amounts to a wide review of the difficulties and the unusual circumstances that MW faced in trying to defend one claim, but decide whether it was the right time to bring another.
But that's not an answer to the question. Because what that goes to is your client's internal decision making as to their commercial put it, as to what claim to bring when. The question of notification is a separate question. So what's the excuse for not notifying?
Well, Lord, I don't think I can offer one, because I haven't got this phrase is our skeleton. I understand why my learned friend is, but the context in which that word commercial decision is used, I can show you that in the skeleton. It's talking about the fact that there are these multiple ongoing disputes between parties, the fact that there will be further proceedings in the Surrey claim.
Well, to be sure, so the context is the reasonableness, as you would put it, of the decision. Let's leave out the adjective. The decision to bring the claims sequentially rather than at the same time.
Yes.
But as I think you've just accepted, the reasonableness of the decision doesn't entail that it was reasonable not to notify that decision. Even if the decision was reasonable.
My Lord, again, I that there is in principle a distinction between notifying the existence of a claim and deciding whether you're going to bring it. In the particular facts of this case, even the act of notification would obviously have set hairs running. And I don't want to repeat myself too much, but I again do emphasise that what MW was trying to do in the EWHL proceedings was defend this enormous termination claim. It was running a case that said, we're not liable for termination. In fact, you are. You've terminated too soon. And if that claim had succeeded, I don't know where we might now be. It's a matter of speculation. But even the act of notification, the nature of the claim that we are discussing, it could never plausibly have just been raised and receded. But Lord,
that seems to be a plea that the Aldi guidelines shouldn't apply.
But my Lord, it's as I said in my oral submissions earlier, I have tried to be realistic and accept that the law is very difficult on this because of all the judgments which I mentioned. But I am continuing to highlight, probably ad nauseam now, that in the particular circumstances of this case, let me put it this way, my Lord, the absence of a proper explanation to this court about why there is notification needs to be assessed as for its culpability in the broader context in which that absence is found.
It goes to the question of whether it's abusive
It does.
and what should happen.
Yes.
And leave aside questions about excuses or reasonableness. You've done your best on how it came about
Yeah.
that the decision was made. And more in view about the sensibility or lack of sensibility of that. You accept that you didn't notify, full stop.
Yes.
Then we move on to the question is whether your conduct is abusive.
Yes. And we move on to the Aldi heading, as my Lord Justice Coulson said. I now want to focus more on the other side of Aldi, which is the question of what's the effect of non-compliance, and that gets us into the thread needle. How would this have been managed? How might this have been carried out? And I will try to I'll try to deal with this. Yes, I will put the point. It follows on from what I said before about what would the Aldi letter have contained, and it would effectively be a letter saying we believe that we have been supplied with technology that isn't proven and doesn't work, and you, the employer, have to support that technology.
You could have gone further on the judge's finding. By late September 2019, you could certainly have sent a detailed letter of claim. You could even have sent draft particulars.
Well, my Lord, I think I've done what I can on this point, and I'll now I'll move on.
Your point is that whether you put in more, I'm not just throwing you a lifeline, I just need to understand. Your point is that whether you did your minimalist letter or your maximalist letter, the employer would be all over it like a rash.
Quite.
And of course, all of that, and it's all pure speculation, and nobody on your side was involved, so it's pure speculation for you. Obviously, I appreciate that's speculation, but
It has happened.
Yes.
My Lord, I have offered you a number of hypotheticals,
Yeah,
so I can't complain about you offering.
Well, I mean, it's just clearly the hypothetical. I can't help laughing that the hypothetical in Otrachiti or whatever it's called is one very simple hypothetical.
No. My Lord, perhaps that is a convenient place to move on to case management. And really this goes when one thinks about the merits-based inquiry, it is addressing the effect of the non-compliance ultimately. I took you in my propositions of law and the length of the Threadneedle case, which I rely on as authority for the proposition that you can, and as I put it, it's important that you do conduct this line of inquiry. My Lord is quite right that there would have been a variety of options open, and the judge so found. What I wanted to do quite shortly is make this submission. I submit that it is a reasonable speculation to say that all four of the stakeholders in the earlier litigation would have balked at the idea that the misrepresentation claims be tried together. The four stakeholders there being the three parties and the court.
You say tried together, you mean tried together with the other allegations?
Yes, with the claims
and
that were tried.
you mean by that in a single trial?
I do. Yes.
Would you accept that there's a difference between two trials in one set of proceedings and trials in separate proceedings, not least because of the res judicata effects?
I accept there is. I mean, of course, there is a difference. I don't know, my Lord, if I recognise the force of the difference immediately. At least in the context of abuse, where the question is at its core, is Outotec being vexed twice where it would otherwise have been vexed once? I don't immediately recognise that distinction carries much weight, but it is probably me failing to understand it. My Lords, the court, doing the best we can, in Mr. Justice Pepperell's judgment, I want to show you just paragraph 8 to 10. He made very plain the scale of the challenge that he faced. It's a challenge which, in my Lord's earlier lives, you will likely have faced many times in large trials. But you find his judgment, summary bundle, tab 5, supplementary bundle, tab 5, page 63 or 65 PDF. I just ask my Lords to read paragraphs 8 to 10 of that judgment. So that's page 63, paragraphs 8 to 10.
Yeah, when I read those paragraphs in preparation for today's hearing, the impression I got, and you correct me if I'm wrong, is that the judge was, shall we say, not best pleased by the lack of assistance he'd received from parties. In other words, his complaint was that the trial was too short. It wasn't that the issues were unmanageable. It was that there was a lot of material and he didn't get quite as much assistance as he would have liked.
I'm going to, with respect, differ on that, my Lord. I mean, I am at a difficulty. I wasn't there. Mr. Williamson, the counsel, was. I would submit that's not an entirely fair reading of those passages. The judge pays tribute to the efforts of counsel involved.
Increasingly evident there were important areas of the case where the parties mounted no or very little challenge to their opponents' cases, either through cross-examination or submissions. That, to me, was the key quote.
My Lord, you may be right, but without being opportunistic, I suppose one might say that does that assist me? Because if this trial was too short, and it should have been even longer, then query where again to the misrepresentation. I mean,
Well, indeed. I see the force of that.
if one adds in the misrepresentation case, one adds in 4 years worth of disclosure between 2011 and 2015 in relation to several projects. If one adds in, you will deal with that. What do these paragraphs then say? Are the complaints from the judge even louder, as my lord reads them? So whichever interpretation one puts, I think the neutral way of putting it is it was an incredibly difficult trial. I hear today from Mr. Williamson the fact that I hadn't appreciated that everyone was wearing their masks as well. It must have been incredibly demanding. But my lords, I think you probably have the point. It's in our skeleton. I don't want to labour it. Our essential submission is that the additional evidence, the additional legal issues, the additional points on the different remedies that would have been pursued, would have added enormously to the burden that the judge already faced. And this is before one even considers the difficulties, as I have characterised them, of running these particular two horses at once. One focusing on pre-contractual misrep and the other focusing on the events towards the end of the piece. So I say the position of the court can reasonably be inferred from what almost 15 months later Mr. Justice Pepperell was saying. The position of the employer we can reasonably circulate. The employer in my submission would obviously have been hostile to the introduction of a raft of new issues, the resolution of which would have made no difference to its claims. I think I've made that point. The prospect of delay to the timetable would be something when new issues emerge downstream. MW's position is apparent. MW would obviously have preferred to litigate the misrepresentation claims separately. And I do say that the likelihood is that however it presents it now, it's hard to imagine that Outotec would have been champing at the bit for these issues to be brought forward and tried at the earliest opportunity either, given the nature of the claims, given the exposure to which they would have put Outotec. It needs to be remembered that contextually Outotec had actually managed to get itself into a pretty strong position. They had knocked the contractual claims all but out. The scope of the contribution proceedings they were facing by the end of 2020 was limited. They were sitting pretty. So if these proceedings had been, if there'd been a proposal to expand them and bringing these in, and add that to the trial again, I submit the reality is that they would have been strongly against it. Now, I am speculating.
If they had known that you had a card on your table that would have required them effectively to go through all of this trial for nothing, because you would claim it all back again in a second trial, they might have had a different view.
They might. I'd have to
concede.
I think have to concede.
I mean, I understand what you said, but I think we have to be. It does really depend on precisely what information is given. I mean, that's one of the things I make it plain. I stub my toe on that effectively this is an attempt to snatch back the result, as far as Outotec were concerned, of the first trial.
Well, the last thing I wanted to say on this topic was I've offered various speculations, but if I can give you something a bit more firmly rooted, which is my lords might want to consider CPR 20.9, because CPR 20.9, I don't know if my lords have their white
20 or 30?
20.9. It is the provision of the rules that applies where the court is considering whether to permit an additional claim to be made, but also whether to require an additional claim to be dealt with separately from the claim by the claimant against the defendant. So it is a specific part of the procedural code that addresses this case management question as to how different issues should be tried. And I am conscious that this is not a point taken in my skeleton, but the court may be assisted by the factors in Rule 20.9(2) that the judge is encouraged to consider when deciding that type of issue. And they include the degree of connection between the additional claim and the claim made by the claimant and the defendant, whether the additional claimant is seeking substantially the same remedy which some other party is claiming from them, and then some irrelevant issues about capacity. All I say there is that there is some procedural framework with which to clothe these submissions about how the trials might have been played out. Now, my lords, my alternative submission under this heading is that at the very least, the judge below was right to say there was considerable doubt about whether the misrepresentation claims could ever have been tried at the same time as the EWHL claims. I've spent some time earlier reminding my lords as to where the burden of proof sits and how I describe it. And I do submit that he was clearly right in his finding. Sorry, let me rephrase. In finding that it was not clearly established that the trial could have all taken place at one time, he was right to apply a rigorous burden of proof on this point as a matter of authority. And the doubts on this issue count against Outotec, not against MW. Heading 6 is the inquiry focused on the effect of the second action on Outotec. I have covered some of this ground already. I do say, again, that the fact that there was always going to be, or there is always going to be, a further trial on these issues in the separate proceedings in relation to Surrey weighs heavily in the balance. I submitted earlier, and I repeat, that where we have come to rest in the claim is that the misrepresentation claims will now be tried in a desirable way, because there will be a single trial looking at all these overlapping misrepresentations as they apply to the two projects that are not subject to an arbitration clause. I say that the course steered by the judge was an appropriate one and a sensible one, and to borrow and then not develop Mr. Fleming, in relation to Mezzo, he used the pithy expression that Mezzo can't complain of abuse because it's not been vexed twice, it's not even been vexed once yet. And that found favour with the judge below, and again, that part of the appeal was dismissed. I say that there is a similar problem for Outotec, that they can't complain that they are now being vexed twice where they should have been vexed once, because there are only going to be two trials in any event. And it becomes a question of sequencing and timing. I heard my learned friend make some submissions about this and about the effect on witnesses. I'm bound to say that, with due respect to him, the difference between cross-examining a witness about what he or she said 10 years ago versus 14 years ago doesn't seem, in my submission, to be a hugely significant one.
But that's a decision that the court should make.
I accept that.
It's not a decision that one party can unilaterally or should unilaterally make.
I accept that.
I mean, these are all fair points, but the bottom line is it's not for one party to decide.
No. And that was not my submission, my lord.
No, I understand that. But I'm just picking you up on the possibly overstatement.
I'll move on from that. But Lord, the only other thing I wanted to do, just by way of a counterpoint, perhaps to show you the minority of the cases in the authorities bundle where there was a strikeout, and to make a point about overlap, because as we've established through discussions, submissions have been made about the extent of the overlap in this case. But my proposition is that on the cases where you actually find abuse established in the previous authorities, which all turn on their own facts, it is a common feature that there is a very extensive degree of overlap.
Well, that reflected the origins in Henderson and Henderson.
Exactly, and indeed in some cases a total overlap. And that is not this case. And indeed, to be fair to Mr. Williamson, I don't think he says it is either.
No.
So, my lord, I won't take you to those authorities, but I will simply make the submission that
that's where the original question of abuse of process back with the same thing a second time.
Yes, and it sits in the in the hierarchy of the overarching consideration. That I was going to restate my course position, but I think I've done that sufficient number of times in my submission, so I'm not going to do that. Then heading 8 was the position of
Wait a minute, so let me just make a note.
Sorry.
Refinement of central submission.
Done already.
See above.
See above.
Yeah.
The final heading is just this discrete issue in relation to Mezzo, and I don't want to open up issues that are not really actually before us, but it was submitted again orally, and the point is taken in the skeleton that I think in response to the submission we make, that one of the broader pictures. Let me start this submission again. One of the points we have made in our skeleton is that there is an element of futility to all of this, because the claim against Mezzo is going to continue anyway, and that Outotec's witnesses, its documents, will all be part of that proceeding. So we make that submission. I don't labour it, but it's there. As I understand it, one of the things that is said in opposition to that is, well, actually, the parent company guarantee claim may yet fall away. Now, as to that, it's addressed in paragraph 66 of the Learned Friends skeleton, and perhaps I should just show you in that core bundle page. Core bundle tab 10. And paragraph 66.
489.
489.
490.
490, thank you, my lord. Now, 2 points made, and I want to make 2 short points in response. So just, you can see in paragraph 66, it should be noted that there remain potential defences to Mezzo. That's what's put. Now, the first of those is that there is potentially a issue as to whether MW's instant claims were properly notified in accordance with the guarantee. Now, with due respect, there's either a live issue or there isn't. And what I believe is the pleaded position, and I'll let Mr. Williamson reply on this, is that we have asserted that we made a valid demand. They have said in their defence we can't actually find a copy at the moment. And that's it. Now, there's no fully pleaded assertion that we have not complied with the demand on guarantee. The second point is, my lord, effectively an expression of the point argued below, defeated below, and rejected by my Lord Justice Coulson at the permission to appeal stage, which was that, in fact, there is an argument available that the striking out of the Outotec appeal would render the claim under the parent company guarantee unavailable. That issue has been determined. So, my lord, I don't know to what extent these points really are being pressed, and I don't want to take up court time, but for the record, we say that these points, for the reasons I've given, are not good points. And if they do need to be dealt with, then you have my submissions on them.
Just on that second point, what is the relevant, and now just give me the paragraph numbers in the judgment.
Well, can I take you, while I look for those, can I just show you what you yourself said about this in refusing permissions? I think that...
I said that the contrary wasn't arguable.
Yeah.
Just so I'm trying to identify what the contrary... Sorry, I'm trying to identify what the point was about which I said the contrary was not arguable.
The 2 points were, first of all, it was argued by Outotec that the scope of the parent company guarantee did not extend to embrace claims of the nature of misrepresentation. And the judge said that fails because the parent company guarantee is expressed in very broad commercial terms that it applies to any claims in connection with the project.
Yes.
The second point was that if Outotec's claim were struck out, the effect of that would be that there could be no claim against Outotec, and therefore Mezzo would have a defence or limitation or bar to that claim. And you, my lord, said that doesn't work either because it's a procedural remedy, essentially. Those were the points. Your permission to appeal refuses.
Yes, I've reminded myself of those. So that says that the judge's decision, forget about the permission to appeal because that's dealing with the judge's decision. The judge's decision on those points, you say are final and binding.
Yes.
even though they arose on a interlocutory
Yes.
application. Yeah. Well, I remember in connection with point, because it gave me an opportunity to refer to Ashville and Elmer, a marvellous authority where everybody should note the name of junior counsel for the successful party.
We will do so. My Lord, unless I can assist you further, those are my submissions.
I don't have anything else. Thank you very much, Richard. No, thank you very much, Mr. Hale, and I hope that, notwithstanding standing in for Mr. Temmink, it hasn't been too traumatic an experience.
Quite the contrary.
Thank you very much. Yes, Mr. Williams.
My Lord, in reply, just the evidence submissions have been wide-ranging, if I may say so, very elegantly and thoroughly made, Mr. Temmick's absence notwithstanding. Just to look at the broader context, to send in some detail, he accepts that MW were in breach of the guidelines. He accepts that there is no explanation offered as to the non-notification of the claims. He accepts that they could have notified those claims and indeed could, per the judge, have brought the claims. And he accepts, or did not, in my submission, argue against the proposition as found by the judge that the claims should have been notified in 2019 and could very well have been pleaded out at that point. So really what the submission comes to is to say that MW were left in 2019 in such a difficult position that in some way excuses or makes non-abusive the matters which I have identified. Now, he says, for example, that Outotec is a defendant and a Part 20 claimant, not an ordinary claimant. That, in my submission, is a distinction without a difference. He says that there's...
Sorry, what's the distinction without a difference?
Between being a normal claimant and being a Part 20 claimant.
Well, it's a clear distinction, isn't it? Because if you are the original claimant, you determine that you are going to bring proceedings at a certain time. You determine the basis upon which you're going to bring them, and you are the obvious target of the Henderson and the Henderson principle. If you are sued against your will and wish by an employer, you are immediately in a different position because you are already subject to the timetable laid down by the court, over which you have no control. I'm not suggesting it's determinative, but to suggest it's a distinction without a difference seems to me to be putting it far too high.
Well, my submission, MW in the Part 20 proceedings had complete control over what matters they wished to raise vis-a-vis Outotec.
But in one sense that's right. But speaking entirely for myself, even allowing for the fact they're in breach of the LD guidelines, one can see, anyone with experience of conducting substantial litigation can see that they've got a problem, which is not necessarily a usual problem. It's perfectly usual to pass claims down the line to subcontractors. You do it every day of the week. You don't, every day of the week, have a situation where you've got a claim which, if you bring it, will blow your defence against the employer completely out of the water, which is what it would do.
Well, just pausing there, my Lord, that point was raised at some length before the judge and he rejected it.
He did, but we have to evaluate the strength of the point ourselves, because you are asking us to reject the judge's ultimate finding, which was that this was not an abuse that required the application of the proceedings to be struck out. So you can't say we don't look at it, can you?
Well, I think my first, if we're pursuing the cricket, my first full defensive would be to say, if we wanted to attack the judge's findings, adverse to them, and we could have had a debate about
They're
that.
not, forgive me for being argumentative, I'm not trying to be, but they're not, as you've just outlined, they're not disputing that in accordance with the ALDI guidelines, they should have at least notified. That's that far you've got. You've got to still go the other, and the judge got that far, but he still thought that the balance was sufficient. And you're saying the balance wasn't sufficient. Why can't we bring into the evaluation of this appeal the views that we hold as to what would have happened? Or perhaps you accept we can.
Well, I think I'm making a twofold submission. The first is to say that if M&W wished to argue that the judge's ultimate decision should be upheld on different grounds or further grounds, that would be a matter of respondent's notice. But secondly, in any event, in my submission, the whole edifice or foundations for the edifice which the learned friend has sought to construct are shaky, because what ought to have done was to notify. Once they had notified, I accept that would have come into the knowledge of EWH as well as court and Outotec. And at that point, it would have been for the two decisions would have to be taken. The court would have to decide how the proceedings were going to be conducted, taking into account such matters as M&W wished to raise as to the difficulty of their position, but also, as my Lord Justice Coulson pointed out, there would have needed to be some hard thinking on the part of M&W as to what realistic case they really wish to make. It's not in my submission. Change every conceivable point at our leisure. If it really is the case, as new proceedings, there has been massive fraud by my clients over a very long period, and essentially, the learned friend did not shy from the term. Lied, he used the term on a number of occasions. We have lied and we have given them rubbish equipment, only unsuitable for the function to which it was to be put. That's their case. Now, if that really was their case, I agree with my Lord. It's completely different from the situation of saying, well, we weren't negligent, but if we were, it was the fault of the subconsultant. It is an extreme case, but in my submission, if the ALDI guidelines are to have any validity at all, then this is precisely the sort of situation in which a party does need to know.
Just forgive me once more, in the original proceedings, did Outotec dispute the defects claims?
In the main, yes. There were some concessions, but in the main it was disputed. But in relation to, I was just responding to my own friends about submissions about the supposed novel features of this case. The fundamental, he says that their central objective was defensive, but the fundamental point, as has been canvassed in argument, is that this misrepresentation claim, if right, would have taken MW out of any liability whatsoever. It was a trump card, and it was held face down, and there has been no adequate explanation. My Lord, so far as the evidence of Mr. Belishka is concerned, can we just see what the judge said about that? That's call 1 at page 69 on 1. I made a submission that the court should be cautious on placing too much weight on Mr. Belish's evidence where he was not the solicitor in previous proceedings and does not identify the person who was the source of the information or identify the documents. I accept this criticism. Indeed, in my view, Mr. Belish's law extent as a whole is unduly replete, etc. Now, my lords, it was open to M&W to put evidence before the court, for example, from Mr. Roy Meakin, who I think may have given evidence in front of one or more of your lordships, who was a relevant manager who gave evidence at the trial, about the difficulties which M&W had in 2019, and they didn't do that. And my suggestion in relation to my Lord Justice Stuart-Smith's point, the court should be slow to conclude that the difficulties were as now submitted in the absence of any evidence to that effect. My Lord, it was also submitted that there were overlapping issues between the three projects, Surrey, Leeds Seat and Hull. However, I don't need to turn it up. As we have pleaded in the defence, these three sites have three different sites, differences in the technology, differences in the personnel engaged, and of course, Leeds and Seat is being dealt with in an arbitration in any event. So little weight. Now, going back to Malone and Friends' submissions on the law, there were three matters I wanted to pick up. First of all, Malone and Friends submitted that you should be cautious regarding matters as irrelevant, given that this was a broad merits test, and he referred to Goldberg at paragraph 57. In my submission, by reference to the passage in Aldi, which I showed you this morning, you have to wrestle with the question of whether the judge has taken into account immaterial factors, and that is a matter for you. Malone and Friend also submitted that there are circumstances in which steering a proper course may involve making difficult decisions and different proceedings. My lords, that's obviously right, but A, that's a fact-specific investigation, and B, of course, Aldi themselves were not subject to the Aldi, you cited Aldi in that motion, Aldi themselves were not subject to the Aldi guidelines, which only emerged from the case itself.
If we decide that he's failed to take into account a material consideration, or has dealt with something that is immaterial, then what's the route? We set him aside and make our decision for ourselves?
That I think is where we get to, yes.
And what then do we do with the weight that he gives to different features that the judge did take into account?
Well, my lord, I think the realistic answer to that is once you've concluded that there's been something which is Aldi non-compliant, by which I mean Lord Justice Thomas's list rather than the Aldi guidelines, then the judgment goes in its entirety in principle. But clearly, then this court has to carry out its own evaluative process, and in respect, for example, of the assessment which the judge made, the point I was just on, the evidence of Mr. Belishko, that is entitled to receive due consideration. The Malone Friend spent quite a considerable amount of time in relation to MW's conduct, the difficulties of the situation in which they found themselves. But it dovetails what Malone Friend has just put, and that my lord's just put to. The judge took due account account of that. And if we get into the judgment, page 71, the proper analysis of the judgment in my submission is that when he deals with could, and that's not subject to Millen Friend accepts he can't go behind that. Then he deals with should, and in my submission, it's only really paragraphs 120 and 121 which deal with should, and his conclusion is that they should have given notice of their claim. And the remainder of the paragraphs in that section, 122 to 130, are really dealing with the question of how a court might have case managed the matter if LD had been applied. And so far as that is concerned, the learning friend submitted that a case manager would inevitably have that there had to be 2 trials and that this misrepresentation claim would go over. As to that, I make 2 points. One is this has all been considered and dealt with by the judge, paragraphs 125 to 129, and he was not impressed by that. But in my submission, it's inconceivable that the court would not have wanted to find a way through the thickets before it.
Can I just ask
yes.
you about that? I was looking again at what the judge said about that, and in 125, he firmly rejects the submission the judge would have decided the case would be unmanageable if the misrepresentation claim was to proceed alongside the existing claims. So he's quite, as he himself says, firm on that. But then looking at the alternatives that are considered, the only one that seems to have been canvassed apart from a global trial is the one that's canvassed in 126, which is a Part 1 trial dealing with the issues that he identifies in A through to E, and then a Part 2 trial with smaller defects and perhaps quantification of the misrep claim. Those seem to be the only ones that were canvassed. So, but they don't seem to me to be the only ways in which you could divide this up.
No, and in my submission, as I think Lady Justice Arnold said in the Threadneedle case, one needs to be wary of retrospective speculation as to what might have happened. But it's not necessary in my submission for this court to reach a conclusion on how it might have been case managed. It's in my submission sufficient to say that the court, if apprised of the misrepresentation claim, would have wished to case manage all of the issues in a sensible fashion. There were a number of possible ways of doing so.
Well, doesn't it fall into the category of consequences? Because I think you accepted in opening that non-compliance with the Audi guidelines didn't inexorably lead to the conclusion of abuse of process. You said it's a strong pointer, it's a high risk, etc., etc. And it must follow from that if there was non-compliance, the court must consider what the consequences of the non-compliance were, and inevitably that must involve some degree of consideration of how the matter would have been managed if it had been compliant. Isn't that right?
Yes, but so far as my position as the party complaining of abuse, harassment, etc. is concerned, what my clients have been denied is the opportunity of having their say as to how these various claims against them were to be dealt with. And picking up the point my Lord Justice Coulson made in the course of argument, we would certainly have wanted to have something to say about the proposition that, as my own friend said, we were sitting pretty in the existing proceedings. Didn't feel like that at the time, but let's suppose that's right, and we had good defences to a good deal of it. and yet face down in Malone and Friends' predecessor's hands was the card which was going to make the entirety of that exercise entirely pointless. And just on that point, in the course of Malone and Friends' submissions, there was some debate about big and a permanite and the £75 million. In my submission, if the misrepresentation claim proceeds, then one of the issues is going to require consideration, obviously, of the reasonableness of that sum, but also the causational and the ingredients which have led to that being, which takes one back into effectively all of the issues which were canvassed in the original proceedings.
You're not submitting that an adverse finding on the misrepresentation claim of itself goes into doubt the sensibility of the settlement, are you?
Adverse to who?
Well, because the 75 million would have been assessed by reference to the strength of the employment case against MW. And that surely is not affected if you are subject to the misrepresentation claim and lose it. It wouldn't cast doubt on the settlement.
No, but one has to consider whether that is a reasonable settlement, which does require one to look at the strength and weakness of the original proceedings.
I thought you might be going a bit further than that and suggesting that if you lost the misrepresentation claim, that would cast doubt on.
No,
No. Thank you.
Next, so far as defects are concerned, just to be clear about that, we have not yet pleaded defects, and if I could just show you what we have pleaded, that's Core Volume 2, Tab 8, page 380.
Sorry. Core bundle.
Core Bundle 2, Tab 8, page 380. So the position is paragraph 2 sets out the history, and then when the judgment was handed down by Judge Davies, we've looked at paragraphs 144 and 145, and he directed that we didn't need to plead to the defects pending clarification of what was relied upon for the misrepresentation, and so we have not pleaded to the defects in But the overall point is that the defects relate to the same plant and equipment as already dealt with in the proceedings, and albeit that to some extent the same plant and equipment. So far as the defects is experts looking at this purposes of the original proceedings, and we are now going to to go and look at the same plant and equipment again, potentially in relation to both the same defects and new defects. So far as that is concerned, Malone Friend passed up application notice and drew attention to paragraph 3.
Yeah.
And just to be clear, we didn't abandon that limb of our application. What happened was that between our application being made and the matter coming before Judge Davies, my Lord Justice Coulson had given permission to appeal on one point, the clause 37 point. So we submitted to Judge Davies that we should effectively put that point over and see how the land lay in the light of the Court of Appeal's decision. So that's why that point wasn't pursued. But my Lords, just finally by way of summary, we say not only is there a breach of the Audi guidelines, which puts M&W at high risk of being held to abuse the processes of the court, but also that we are significantly harassed, prejudiced, and oppressed by that. And as my learned friend, as my Lord Justice Coulson pointed out in the course of argument, it's all very well for a learned friend to say now, well, it doesn't matter whether your witnesses are giving evidence about something that happened 5 years ago, 10 years ago, or 15 years ago. That is a matter for the court to determine and consider, not for his clients unilaterally. And what we have been denied by the way in which M&W have gone about this is the opportunity to involve ourselves in the case management process, both of the original proceedings and the new proceedings back in 2019, and that is precisely the mischief at which the ALDI guidelines and the cases which have followed it is directed. So, my Lords, those are my submissions in reply, unless I can assist further.
No, thank you very much, Mr. Williamson. Right, well, thank you both very much for your excellent oral submissions, and thanks to those sitting behind you. You'll be unsurprised to learn that we will not be providing an extended judgment this afternoon. We will take time to consider. You will have our judgments in draft when they're the handing down of the judgments in draft is so that you can correct any typos or matters of that kind. It is obviously not an opportunity to re-argue the case. The judgment itself, once you've had back your corrections, will be handed down electronically, and there will be no need for anybody to attend. We would ask the parties to agree an order so that that can be finalised at the same time as the judgment. If there are any matters on which the parties can't agree for the purposes of the final order, then very short written submissions only on the points of difference should be provided, and we'll deal with those matters on paper. And finally, as you both know, but I must reiterate, when you get the draft, it's the subject of an embargo, and therefore it is not to be shared with anyone other than the people on the list which my clerk has prepared. Thank you all very much.
My Lord, what would be the most convenient way for you to receive the amended particulars of claim in electronic or in hard copy? Or both?
Speaking for myself, a hard copy. So if you're doing one, then maybe you could do three.
Certainly.
And if your instructing solicitors could make arrangements with my clerk, they have his details, then if those can be provided in the next couple of days, that would be very helpful.
And would it assist, my Lord, to have a copy of the transcript of the hearing below, just while we're dealing with things?
Speaking for myself, no. No,
Thank you.
no, that's a 3-0.
It's another generous offer.
Yeah, that generous offer we'll refuse, but the generous offer of pleading we'll accept. Thank you all very much.
All rise if able.